Did you know that one innocent mistake in a recorded statement can cost you your entire injury claim? Here's what you must avoid. Hello, I'm attorney Marc Lopez. I've been doing car crash, slip and fall, dog bite cases for nearly 20 years. And I want to talk to you about recorded statements. Now, the purpose of this video is giving guidance to viewers on whether or not they should give a recorded statement after a car crash, a slip and fall, dog bite. But basically, whenever the at-fault party's insurance company is calling to try to get you to give a statement, you should watch this video before you do that. So what is a recorded statement? A recorded statement is a wonderful tool used by insurance companies to diminish claims. They love recorded statements because literally the more you talk about your case, literally the less money they end up paying you. That's just a fact. And so the purpose of the recorded statement is to try to lock a person in to what happened, the extent of the injuries, and try to use everything they say against them. So they call you 3 days after the accident. Hey, how are you feeling? I'm pretty beat up. But you feel better than you did before, right? So thank goodness you're on the mend. Yeah, I do feel a little bit better. Oh, you just admitted that you no longer are in severe pain. You're on the mend. If you get further treatment later on, they're going to say, wait a second, stop. You said you were feeling better 3 days later. Now you're getting more treatment? Come on, man. You're trying to milk this thing for everything it's worth. This is a cash grab by you. If you say something like, hey, well, you were walking and maybe you could have been paying a better attention to where you were walking, you wouldn't have slipped. Well, I mean, maybe I could have been paying better attention. Oh, you just admitted you're partially at fault. We're going to diminish your claim by comparative fault. Oh, you're driving a car? Hey, don't you agree maybe if you've been driving a little bit more safely, this accident wouldn't have occurred? Well, you know, I didn't blow the stop sign and hit me, but I guess if I could have anticipated them blowing the stop sign, oh, you just admitted that you partially at fault and you took some responsibility. It's all a giant trap to try to get you to make a statement where they can argue that you get paid less, or if at all. So be super, super careful. And the worst part is insurance company representatives, adjusters, they're trained so that you believe that they're your friend. They'll call acting concerned. How are you doing? What's going on? Are you okay? And they'll warm you up before they ask for the recorded statement. They're going to just warm you up. Hey, I'm just trying to make sure you get compensated. Hey, I know I work for them, but I'm on your side. Our guy clearly was at fault. We just got to get a statement from you. And after they've established a relationship, after they've made you think that they're your friend, they're going to jump on this. Hey, as part of my file, I just have to. My supervisor's on my butt. But would you mind giving me a recorded statement so I can tell my supervisor that we've done it? It's the formality, just protocol, something I have to check off my list. But the reality is, the insurance adjuster, no matter how friendly, no matter how nice, their only job is to pay you as little money as possible. In fact, they get performance reviews based on how little they pay you. They get bonus based on how little they pay you. And if they pay too much, their job is gone. Just understand they're not your friend, even if they do come across as friendly. Now that you understand the purpose of recorded statement is to try to screw you out of as much possible compensation, we understand they are not your friend. They're trying to diminish how much they pay you. So let's talk about your legal rights. In Indiana, you have no duty or responsibility to give a recorded statement to an insurance adjuster for the at-fault party. Now, if a lawsuit is filed, you will have to give a statement called a deposition. There's some other things you may or may not have to do, but when you're just negotiating with the adjuster, you do not, and you have no requirement to give a recorded statement. Now, there is one exception, your own insurance. So this typically happens in car crash cases. And so your own insurance will call you, hey, what happened in this case? Now, you have a duty to talk to your own insurance, or your own insurance may not cover you. And if you think to yourself, well, I don't care about my own insurance, I'm going after the other party's insurance. Well, guess what? The other party's insurance may not be enough for you. And if you're a smart consumer, you likely have underinsured and uninsured motorist coverage, which will come in to play if the other at-fault party's insurance isn't sufficient. They only have 25-50 coverage, where because you value your family, friends, and your job and your health, you have maybe 100, 300, or 500, a million, who knows? But you do need to cooperate with your own insurance, or there could be issues later. So you do have to give a statement to your own insurance company. Now that can get complicated if you have Allstate and the at-fault party has Allstate or State Farm or whatever. So if you are getting calls and your insurance is the same as the at-fault party, you need to always start that conversation with, and you represent me in this matter. You're not representing the at-fault party. And they're going to be honest with that because they don't want to get in a situation where they're in trouble, because that would be awesome for me as an attorney, not awesome for the insurance company. So Just be careful if your own insurance is the same company as the at-fault party. Insurance companies are very good at separating those two. Just always start that conversation. You're my insurance, correct? You represent me. If you ask those two questions, you're going to be fine. You must cooperate and give a statement to your own insurance company. Now, if you're watching this video, maybe you're handling the case on your own. Maybe you're trying to figure out if you should get an attorney. I'm going to give you a few little tips here. You would never give a recorded statement if you have serious injuries. We're talking broken bones, surgeries, long-term treatments. If you're handling that type of case on your own, it's a terrible idea. You need to get an attorney involved immediately and talk about why you would never give a recorded statement, because they are going to do every trick in the book to try to minimize and pay you as less as possible, because they know if you have broken bones, surgeries, or long-term injuries, that's a big case. And they're going to do every trick to try not to pay you or pay you as little as possible. Please talk to an attorney. Do not be trying to handle this on your own. If you have a complex accident, multi-vehicle or contested liability, that's another big key. You need to get an attorney involved, because if there's multiple cars involved, or if there's just a complex set of facts, who's responsible for X, Y, and Z, they're going to try, again, do every trick possible to get you to make a statement that hurts your case. They can pay you less. I always tell people this, the more complicated the case is, like a complicated recipe. You can't mess up an apple pie recipe. Maybe it doesn't taste like your grandma's, but apple pie, apple, sugar, cinnamon, it's going to taste okay. But the more complicated recipes, lemon meringue pie, complicated case. Lemon meringue pie has all these ingredients. You got to whip the meringue. You stomp around the house, meringue falls, tastes like crap. Complicated cases can easily go wrong. You need to get a professional involved. The third example is you don't ever want to give a recorded statement where you feel pressured. If they're pressuring you to give a recorded statement, there's probably a reason for that. Maybe the case is bigger than you think. Maybe the case is more value than you think, and they're trying to pay you less, and they're trying to push back. So if you feel pressure, do not give a recorded statement. Now, like all things in law, there's a giant except, and I wish it wasn't, because I feel bad doing that, but law is complicated. There are 3 instances where you likely want to give a recorded statement. Number 1, we already talked about your own insurance. You have to, or you're going to jeopardize your coverage with your own insurance company, which you may not know you may need later. So you always have to give statements to your own insurance company. Just be careful if your insurance company is the same company as the at-fault party. You always want to ask those 2 questions. You're my insurance and you represent me, correct? Number 2, property damage. Now, if you're dealing with property damage, even if you have an attorney, the attorney will help guide you, but literally the attorney will have you typically deal with property damage on your own, because it's faster that way and it puts more money in the client's pocket. If you handle the property damage on your own, the attorney is not going to take a cut of that property damage as attorney fees. So at this law firm, we will help guide our clients, but we do not get directly involved with the property damage, but we will guide clients and help them push it along. In property damage cases, you can talk to the insurance company and you can tell them, hey, I'm talking about property damage only. And again, insurance companies are very good about dealing with property damage only claims versus injury, because they don't want a situation where someone's claiming that they were tricked. So you can talk about property damage, what my car was worth, the mileage, the condition of the vehicle. We're not talking about how the accident occurred. We're not talking about anything like that. Now, sometimes things come up during that property damage. You want to let the attorney know, well, your car is worth $10,000, but you're 30% at fault, so we're going to pay you $70,000. And that's a situation where you want to get the attorney's input. So this law firm, if that were to happen, the client would call us and then we would guide them from there. So property damage, you can give a recorded statement, but again, talk to the lawyer before you do that. If you truly are set on handling the injury case yourself, you likely are not going to be able to settle the case unless you give a recorded statement to the at-fault party's insurance company. So that's just a fact of life. So if you are handling the case on your own, you do not want to get an attorney, or an attorney, just the case isn't big enough for an attorney to help. And I will tell you, at this law firm, we talk to people all the time. And sometimes we just don't take cases because the case isn't big enough. But usually we give the client a game plan on how to move forward. Be careful when you are giving a statement to the at-fault party's insurance company. You don't want to do anything where they can call you a liar. You don't want to say anything that could come back later and bite you in the butt. You don't want to do something, well, I can't even enjoy my life anymore. It's too broad of a statement. They're going to show you, they're going to have a picture of you on social media smiling. You're enjoying your life 3 months later. You're a liar. So with that, just give accurate answers to their questions. Don't volunteer things. The best example I can give you, if somebody asks you, do you have a watch? Normal response is, yeah, I have a watch and it's 5 p.m. No, they didn't ask you what time it was. They asked you if you had a watch. Answer the question asked And don't embellish, just be truthful and short. Don't give long, drawn out answers because that's where people make mistakes. So if you do give a statement, you want to be concise and straightforward. Answer only what's asked. Don't guess or speculate. Clearly state if you don't know the answer. You want to be truthful and consistent to avoid claim denial due to inaccuracy. So if you do give a recorded statement, write down what you're saying, maybe even record what you're saying on your iPhone or Android so you can consistently give the same response if asked in the future. You want to limit the scope. If you're only talking about the accident, talk about the accident. Don't talk about prior injuries, whatnot, although they may be entitled to what those prior injuries were. And it's possible you want to get your statement ahead beforehand. Tell them, hey, I will give a statement, but what are we going to talk about so I can get my thoughts together? Just be on the lookout. Insurance companies are trained to use leading questions in order to add confusion and try to get you to make them inconsistent statements. So avoid pressure or being rushed into giving statements immediately after car crash, slip and fall, any type of accident. And just watch out for that. And the best part about having an attorney is we can help guide you through these roadblocks. I just can't stress enough, being in a car crash, slip and fall, dog, but any of these injury cases, it's stressful. Having an attorney that knows what they're doing, how to handle it, takes that stress off of the injured person. Because at the end of the day, the only responsibility of an injured person is to get better. It's called mitigation of damages. It's a fancy way of saying, go to the doctor, try to get better, and try to move on with your life. That's mitigation. And it's hard to do that when you're trying to handle all the insurance aspects, plus live your normal life, plus do all the normal things you're supposed to do when you're a human being alive in this world. I cannot stress enough, if you have been hurt through the negligence of another person, you owe it to yourself to at least call an attorney to get some idea of what to expect, what's going on. You know, again, people call us all the time. We consistently just talk with people, even that are not our clients, just to kind of give them an idea of what's going on. Yeah, we are in a business. We are trying to assign clients to represent them, but we do this business because we love to help people. And that's everybody that works at this law firm. If you're dealing with an injury, slip and fall, car crash, dog bite, we understand you're probably experiencing a great deal of frustration because, again, you have to deal with this incident and all the normal things in life. Allow the Marc Lopez law firm to turn that frustration into compensation. Give us a call, 317-632-3642. We would love to talk with you.